It's about 2 weeks.
That's a pretty bad day.
Okay.
So we could get it later.
You do the 22nd.
That's going to be my swearing in, so we're trying to keep that really long. My last term.
What about 29th?
29th is good.
We'll do it.
December 29th will be the next hearing for a pretrial at 10 a.m.
Thank you, Judge.
You're welcome.
State of Ohio versus John M. Curry, case number TRC 23-1781, A and B.
Sir, are you John Curry?
Yes, sir.
Mr. Curry, the state's filed a complaint alleging that on November 26th at 6:08 p.m. in Fayette Township, that you were driving a vehicle while you were under the influence of either alcohol or drugs, or a combination of those things. And it's alleged you submitted to a urine screen. Those urine samples are a package. They go to a lab in Columbus for testing, and it takes several weeks to get the results. So I don't have any results right now. We'll get the results eventually, but not today. It's alleged this will be your third lifetime, but it's been quite a while. It's been over 20 years since you've had an offense, so it would be under the first offense sentencing guidelines if you were convicted. The maximum penalty for that is 6 months in jail, $1,075 fine, 3-year license suspension. That's the most you can receive if you're found guilty. There is a minimum. The least you can receive if you're found guilty is 3 days in a treatment program, a $375 fine, and a 6-month license suspension. You understand?
Yes.
The possible penalties? You're also charged with a lane violation, left of center. That's a minor misdemeanor, no jail time. Maximum penalty is $150 fine. So those are the two charges. Do you understand these charges?
Yes, sir.
And were you here when I explained rights of the defendant?
Beg your pardon?
You understand your rights? I explained those. I'll have
Yes.
you go over
Yes.
it again. Do you have any questions about your rights? How do you wish to plead to these charges?
Not guilty.
Do you want to be considered for a court-appointed lawyer?
No, I'll get my own attorney.
Okay. How much time do you need to do that?
Couple weeks or whatever.
Well, we'll go longer than that because I can tell you it's going to be 8 to 10 weeks before we'll ever get the results back. So there's really not a reason to come back till we know what the urine screen test results are. So that's what I'm going to go out and set it probably in a couple months. Okay, I'm going to set it about Groundhog's Day, February 2nd. We will have court that day.
Okay.
And that's about 2 days out. So that's going to be your next hearing, February 2nd. Pre-trial, and that's 2024, February 2nd at 10 o'clock. I'm going to put down that you will hire an attorney. You can sign a $1,000 signature bond. Do you understand what that means?
Yes.
Any questions, sir?
Beg your pardon?
Do you have any questions?
No, sir.
Okay, be back here February 2nd, unless your lawyer tells you they've made arrangements to have a different date. Then you come when they tell you. Okay, that's all.
Thank you, sir.
You're welcome.
State of Ohio versus Kathy Langdon, case number TRD 182844, TRD 163011. Kathy Langdon.
All right, Kathy Langdon was arrested on a warrant, and she posted a bond through Mr. Sowers, and she still didn't come to court, even after she posted a bond. So, Kathy Langdon, if you're here, come into court. It's been called for, has not appeared, so what I'm going to do, so I take a picture of the bond, send it to Mr. Sowers, and he'll know that means that she did not appear. So I'll set a bond forfeiture hearing. Let's make it the 29th, December 29th. Usually don't have to wait that long because he will go round her up, take her to jail. December 29th for bond forfeiture.
State of Ohio versus Dolores E. Hill, case number CRB 23568, CRB 23536.
That's you, ma'am, you're Dolores Hill.
Yes, sir.
I'm showing that you had a pretrial in this court on November 13th that you did not appear for.
Yes, sir. I was in Charleston, and I was told that my brother-in-law would speak on my behalf, saying I didn't have to be here, and I was told that he told them that I was in Charleston and was seeking treatment.
Well, and Tyler Smith is your lawyer, right?
Yes, sir.
Is he here today? Is he on the
He's
phone?
on the docket. I haven't seen him yet.
All right, ma'am, have a seat. I want you to talk to your lawyer after that's happened, and I'll call you back up.
Yes, sir. Thank you.
He is scheduled to be here today.
State of Ohio versus Cody S. Richardson, case number TRD 231750, A, B, and C.
Sir, are you Cody Richardson?
Yes, sir.
Mr. Richardson, it's alleged that November 17th at 6:18 p.m. in Fayette Township, you were driving a vehicle involved in a collision and left the scene. That is a first-degree misdemeanor. Maximum penalty is 6 months in jail, $1,000 fine. It's also alleged you were driving without a driver's license. That's a minor it's what's called an unclassified misdemeanor. Maximum penalty is 500 hours of community service and $1,000 fine. There's no jail time, but there is community service and a pretty high fine possible.
Yes, sir.
Also, it's alleged you ran a traffic signal light. That's a minor misdemeanor. Maximum penalty is $150 fine. So you've got 3 charges.
Yes, sir.
Do you understand these 3 charges?
Yes, sir.
And you understand your rights?
Yes, sir.
How do you wish to plead to these?
Not guilty.
Do you want a lawyer appointed? One of these is a jailable offense, so you have a right to get a court-appointed lawyer if you can't afford one.
Yes, sir.
You want to be considered for a court-appointed lawyer?
Yes, sir.
You have a job?
No, sir. After that accident, I lost my job because of it.
Okay. When's the last time you worked?
It would be the Friday before that accident.
What were you doing then, before you lost your job? What kind of work were you doing?
I worked at a gas station.
Okay, paid by the hour?
Yeah. That's the
How much
same
more?
way I was making that Burger King, $12 an hour.
Okay, you're qualified for court-appointed counsel, so I'm going to appoint Attorney Roger Smith.
Yes, sir.
He's seated right behind you. He's going to be your lawyer. Appointing him, I'm entering a not guilty plea for you.
Yes, sir.
Since you showed up on your own, I'm going to let you sign a signature bond. Is this your promise to come to court when
Yes,
you're
sir.
ordered to?
Yes,
It'll
sir.
be a $1,000 signature bond. As long as you come to court, you won't have to post the money. If you don't show up, you get a warrant for your arrest, and then you're required to pay $1,000 as a penalty.
No, I'll guarantee I'll be here, sir.
Just come when you're ordered to, and you won't have to post anything. I'm looking, Mr. Smith, let's see. December is filling up with the holidays and everything that's going on.
Today's the first. Looking at
You can
January.
do the 26th, the 29th of December, or go into January.
That week after Christmas, I'm not going to be in town. I could do
Okay.
January, let's see here.
I can do the 5th. Pretty much anything in January is open.
Let's see. I can do the 5th, Judge.
All right, January 5th will be the next hearing.
See you then, sir.
Yeah. I'll call you.
Then it'll be a pretrial at 10 a.m.
Thank you, Judge.
You are.
This thing, you're free to go.
Do I need this or not?
No, I'll take it. You need this right here. Hang on a second.
Sir.
That's okay. That's not your next time. Next one. I'll give you a call.
Thank you, sir.
State of Ohio versus Ashley Adkins, case number TRD 231717 A and B.
All right, ma'am, are you Ashley Atkins?
Yes.
Ms. Atkins, it's alleged November 12th at 12:34 a.m. in Windsor Township that you were operating a vehicle involved in a motor vehicle crash and left the scene. That's a first-degree misdemeanor, maximum penalty is 6 months in jail, $1,000 fine. Also, it's alleged that you failed to control your vehicle, so that's a minor misdemeanor, maximum penalty is $150 fine. Do you understand these charges?
Yes.
Do you understand your rights? How do you plead?
Not guilty.
Do you want to be considered for a court-appointed lawyer?
I'm going to get my own.
Okay. And it looks like you got a FedEx uniform on, so is that where you work?
Yeah, I drive for FedEx Express by the airport.
All right, do you prefer, you're going to be here on a Monday or a Friday? Do you prefer one of those days?
Monday.
Monday's better. I'm going to make it January the 8th is your next hearing. That's a Monday. January the 8th of 24 will be a pretrial at 10 o'clock. You can sign a signature bond of $1,000. You understand what that means?
Yeah.
Any questions, ma'am?
No.
Be back here January 8th unless your lawyer tells you they've made arrangements for a different day than that.
And you said 10 o'clock?
10 o'clock, January
Okay.
8th.
Alrighty.
State of Ohio versus Tony Taylor, case number CRB 23679 A and B.
You're Tony Taylor?
Yes,
Mr. Taylor, it's alleged you missed a review hearing back in 2014, June 6, 2000.
yeah,
I'm
it's
sorry,
been almost 10 years ago.
June 16, 2014.
Yeah,
And it was on a theft
yes.
offense.
I did my jail time, I already paid all my fines. I paid it all yesterday. I just found out I was on drugs then and I forgot about the court date and I was in and out of rehab and I'm clean now. I got a job. I'm trying to take care of my two stepdaughters. One just got out of mental hospital. That's how I found out that I had a
Yeah,
warrant because they did a background check at their, where she's on probation. They did a background check just to make sure it was safe to be in the house. and I'm trying to get everything taken care of.
Okay. Well, I'll withdraw the warrant since you came in on your own. You did pay off your fines.
Yes.
You got community service
Yes.
to do, you were ordered to do, so.
I was gonna say, is there any way that, I know that you can work, extra community service to pay your fines? Could I pay my community service since I work a lot?
No.
No? Okay.
No.
I'll have to find a place somewhere up in or up there in
Where do you
Milton,
live?
in West Virginia, in Milton.
Milton?
Yeah,
Your Honor, he came and talked to me this morning, and
yeah,
Okay, just coordinate with Mr. Cooper. He's got to approve where you're going to work. Or
Right.
You can come here any day,
Right.
on Sunday and work. Okay, get your community service done. Since you paid such a large amount, I'll go ahead and move it to February. I'll set this for February 2nd for your next hearing. It'll be at 9 o'clock. So the way these work, you have review hearings periodically until you finish everything.
Right.
When you finish, then you won't have any more review hearings.
right.
So get it done. If you get it done before February 2nd, you don't have to show up. Otherwise,
Okay.
you gotta be here at 9
I
o'clock.
will try to get it done before then.
If you don't show up and you got stuff left to do,
Yeah,
then you
then have to get
another
warned again, yeah, I don't wanna do all that.
Okay.
I've been trying to get all this stuff, cause I got all my other fines taken care of in West Virginia, I got my license back, I'm straight, so, I mean, I'm almost assistant manager at McDonald's now, so,
Congratulations on your recovery.
thank you so much. And I'm sorry about missing court and all the other stuff.
Thanks for coming in and taking care of it.
Oh, that's no problem. Do I need to get your phone number and stuff so I can get those?
State of Ohio
Thank you,
versus
y'all.
Aaron
Every day.
Cron, case number CRA 19288.
All right, this was set just a few days ago, November 27th. Yeah, it was Monday. Looks like you missed that hearing. You did make a payment today.
Yep.
So, actually hadn't issued a warrant yet. It was scheduled to be issued Monday. I'll withdraw, no warrant to be issued since it came in today. Set your next hearing for January 5th at 9 a.m. You still have quite a bit left to pay, but once it's paid, you can quit coming to these hearings. January 5th, 9 a.m. is your next hearing.
Make it.
State of Ohio versus Derek C. Willis, case number TRC 22-160 ABC and D, TRC 14901 A and B.
All right, you're Derek Willis.
Yes, sir.
It looks like you missed the hearing.
Yeah, you told me to bring up the probation guy,
November 20th, wasn't it? Was it November 20th you missed?
and I didn't have to come back, but I was under the impression I only had 30 hours and I'd done 42 community service, and it ended up being, you doubled it. I didn't know that.
Your Honor, if I may, I've spoken to him a bunch. In 2018, you doubled his community service for failure to appear. I believe it's for failure, but it was doubled in 2018.
Okay.
And he turned in 30 hours community service, which
With the original amount?
on the 2014 case. So he still had 30 hours on that one, and he has additional community service on the new case.
Okay.
So
It was actually 42, or was that?
I think it's 42 that
Total.
total.
All right, so you're back on track, so we'll, and I'd set it for sentencing because you have a bond up, right?
Yes, sir.
Okay. So we'll set it for another sentencing hearing. When do you think you can finish this?
I'll get it done in a couple weeks, I mean, just do it.
All right, we'll go a little more than a month out. If you get it done, you don't have to come back.
Yes, sir.
So
Just drop it off to him.
January 12th
Yes, sir. Thanks.
will be a sentencing hearing at 10 o'clock.
All right.
Get it finished, you don't have to come back.
State of Ohio versus Shauna Turner, case number CRB 23-227 A and B. She's on Zoom, Your Honor.
All right, Shauna Turner is here appearing by teleconference.
Yes.
All right, and this was set today for review hearing. When you finish, I got a certificate of completion. That was, last summer you completed a residential program. You still have, I'm showing that you've done everything but your community service.
Yes.
When can you get that done?
I did 6 hours, but I'm gonna continue to do it. I'm really gonna be lazy on it.
Well, you're honest. I've got a lot of lazy people, but most of them never say I'm just lazy. Most of them have got 15, I've heard every excuse in the book, why they can't do it or haven't done it or whatever, they're about to do it.
Yeah, that's.
Most people don't just say, I'm lazy. So I give you credit for being honest. Where are you living now?
I'm in Cincinnati still.
Okay. Well, you can do it down there. Just go to a legitimate charity there and have them write something on letterhead, giving me the hours that you've done. Now usually, that's a big court down there. It's a totally different world. But the local courts here, like Scioto County, you go to the municipal court there, you live in Portsmouth, they'll take you and you can work for them, they'll send the hours. I accept that too. If you go to Hamilton County Municipal Court, do some community service there, we'll accept their hours if they'll let you do it. I don't know if they'll let you do it or not. Actually, one of the guys I went to law school with is a judge there, but they have about 20 judges in one building, so it's a little different animal than here. But you got to
Get that done.
Okay, I'm going to set your next hearing. Okay, this is a newer case, so I'm going to give you more time. I'll set it for February 2nd. Get your hours in here, and then you won't have to appear. Otherwise, you got to appear. I'll let you appear by teleconference since you're in Cincinnati, but you got to start making progress on this. Get some community service done.
Okay.
Okay, that's all.
All right, thank you.
You're welcome.
State of Ohio versus Stephanie Plumley, case number CRB 22584.
And you were set for a review hearing on Monday, so you missed them?
Yeah.
Do you have a reason for missing?
Yeah, we was on our way, we had car
Okay,
problems.
you called in and said your car was broken down, so you did at least call, you did make a payment today, so I actually hadn't issued a warrant yet, I won't issue a warrant, it'll be canceled. Give you a new review hearing date of January 8th, 9 o'clock.
Okay.
And you got community service to do, you need to get that done and pay off, you don't have that much left on your phone.
No, I've been working on my community service also.
Okay, get that done, and you don't have, you get it done before January 8th, you don't have to show up.
Okay. All right, thank you.
You're welcome.
State of Ohio versus Cecil R. Gordon, case number CRB 23719.
You're Cecil Gordon?
Yes.
Mr. Gordon, it's alleged that on November 27th of this year, you tried to deprive the local Walmart at South Point, which is Fayette Township. You tried to deprive them of property. That's a theft offense, first-degree misdemeanor, carries a maximum penalty of 6 months in jail, $1,000 fine. Do you understand the charge?
Yes, sir.
Do you understand your rights?
Yes, sir.
How do you plead to the charge?
Not guilty at the time.
Do you want a lawyer appointed?
Yes.
Do you have a job?
No, I don't.
You have no income?
No, I was in a bad car wreck about 4 months ago.
Okay, so you're not working, haven't been working?
No.
I'll appoint Mr. Stratton to represent you. You'll have to fill out a financial affidavit, but he can assist you with that.
Yes.
He's got a bond up, so his bond is continued. All right, Mr. Stratton, I'm looking at probably the last week of December or any time in January.
Last week of December is fine, Your Honor.
Okay.
Be the 26th or the 29th is fine.
Okay, let's do the 26th.
Okay. I'm sorry.
26th will be the next hearing.
just,
It's
okay, it's on the 26th, so it'll be fine. Okay, December 26th is fine.
December 26th will be the pretrial, and that'll be at 10 a.m.
All righty, thank you, Your Honor.
You're welcome.
Let's step outside.
Okay, that, we may have some more arraignments. If you were told to be here for an arraignment, they're still processing paperwork, so we may get to you later. We'll have some at the jail, too, to do by teleconference, but as of now, we're going to go to pretrials. So we need the lawyers and the prosecutor in the courtroom to start pretrials.
State of Ohio versus Emily Bird, case number CRB 23489. John Bird, case number CRB 23490. And Lucas Bird, case number CRB 23492.
Mr. Permines, you're representing the Bird defendants.
That's correct, Your Honor. Your Honor, speaking with the state, I believe the state has had a great issue with getting in touch with the alleged victims in this matter. I think Mr. Guild wanted an opportunity to send them a subpoena prior to dismissing. We have no objection to that.
Okay. Do we have a date when you want to come back to that?
Your Honor, if we could maybe do it, let me see here. December 29th?
Yes.
And would it be possible, Your Honor, to make that kind of as a status, and Mr. Bird's going to be out of town working, if we can maybe excuse his appearance for it, because it's either going to be...
He can be available by phone, or somehow you can reach him if you need to.
That'd be fine, Your Honor.
Mr. Hill, do you agree with that?
We're not opposed to that, Your Honor.
All right. Be a pretrial December 29th, 10 o'clock.
Thank you, Your Honor.
You're welcome.
Okay.
State of Ohio recalls Dolores E. Hill, case number CRB 23568, CRB 23536.
All right, this is Tyler Smith's case. Assume you've had a chance to talk now.
I have, Your Honor. Last time that Ms. had a hearing, she was
in Charleston, right?
Charleston at the YWCA, I believe, and her brother-in-law was always transferring her to court. Right. But she wasn't aware that when she was in treatment, she was supposed to come back for the hearing. But she's finished there at the YWCA. She's now living with her sister, but she's back. She's still with Prestera. That's where she gets her medication, and she's currently on all her medication, which is, I think, the biggest problem.
Council State want to proceed with this. He had any input from, I think it was family that was the complaining party, right?
Yes, it's my understanding.
Not wrong.
That's been pending for a while.
Please close the door.
Like her niece is, her niece is the one who was here there. This is the one. If you remember, this is the one we spent a long time getting her to the hospital. And then we finally get her to her hospital. She was perfect. So they could take her. We didn't. So then the last thing we knew, she was at the YWCA. Last time we came here, she didn't appear. So I don't know where she's still in treatment or not.
All right. So, Your Honor, I've been speaking here with Jasmine to get an update on what's happening. And because of the fact that it's been a few days since we were before the court, we would like to have an opportunity to
have input, further input from the alleged victims on this. I don't know whether this is a matter in which...
Now, was the brother-in-law always came to court? Is he not here today, or?
No, sir, he's not here.
I think she came with her mother today.
Yes, sir.
So, is her mother here?
Yes, sir.
That's good. Can you come up?
There's two separate.
So, is she staying with you? Well, that's good. Well, what I'd like to do is come back and okay. So, Your Honor, Ms. Sniff is here, who is Ms. Hill's mother. She says that they are living in, that Ms. Hill is with her in Louisa, out in the country where can't get in any trouble. Where'd she go? Okay. And the things are going well. So what we would like to do is move this case out another 2 or 3 weeks to make sure that we've talked to everybody who's been affected by this and make sure there aren't any further problems. And I know that when this case first started, there was a referral to River Park Hospital. That
She's at Prestera.
Okay, we want her to continue at Prestera. Yes. And then come back and check on her progress. We'd like a time waiver.
December 26th or 29th?
29th is fine, sir.
29th is fine.
All right. December 29th will be the next hearing for a pretrial.
Thank you, Your Honor.
You're welcome.
Thank you.
State of Ohio versus Chastity Seckman, case number CRA 23688, CRB 23689.
This is Mr. Smith's case for preliminary hearing, actually.
I believe there's a theft charge and then a possession charge. So there's one of each.
She was supposed to be getting some treatment.
Did you go anywhere?
Yes, I would do
Proact.
They don't?
Okay.
They do a drug test.
All right.
We have something to write it on that?
Do you have anything for Proact in writing? This coming Monday? Okay. Your Honor, she did go to Proact. She was, they assessed her, they drug tested her, she was clean. They didn't recommend treatment at that time. It was just sent paperwork. They said it would be here Monday, this coming Monday, so.
Would she be willing to submit to urine screening then today?
You do want to do that? Yes.
Let's do that, and then maybe that'll inform how we go forward. So go do urine screening.
State of Ohio versus Michael H. Tracy, case number CRB 23548.
Mr. Smith's case, pretrial.
I'm all right. She knows about it. She said it's best, she calls me every time I'm right. Hannah Campbell.
Your Honor, our alleged victim in this matter, after having reviewed all the information, we've determined that it would be appropriate to do a 90-day continuance. and dismiss the case with payment of court costs if there are no further problems. And this is, we've reviewed this matter with Ms. Campbell, and she agrees with that. So that's what we would propose.
Mr. Smith, how do you and your client feel about that proposal?
Your Honor, I've talked to Mr. Tracy about it. He's agreeable to it. I know, I believe the last time they spoke with the alleged victim was maybe November 7th, and there haven't been any problems since then. I'd ask to even start the 9 days back from 11/7, if that's agreeable to the state.
There haven't been any further problems since then, so we're not opposed to that.
February 9th then?
That's fine, Your Honor. Thank you.
February 9th will be the next hearing. Be dismissed then if there's no further problems and the costs are paid. He does not have to appear if he's paid the costs and there hasn't been any problems. If he hasn't, obviously if there's been problems, he's got to appear, or if he hasn't paid the costs, he has to appear.
Which is
Sir, thank you very much, sir.
You're welcome.
State of Ohio versus Charles H. Dennison, case number CRB 23566, A, B, C, and D.
This is Mr. Nash's case set for a pretrial today.
Good morning, Your Honor.
Good morning. Okay, it looks like from the file there's been some discovery that's taken place. Is there anything else the court can assist defendant and the state in this matter?
I don't think so, Your Honor.
Set for trial?
I believe so.
Is this going to be trial to the court, or you wish a jury trial?
Jury demand has been filed.
Okay. Do you have a preference as to date? Probably looking at the end of December or sometime in January for a jury trial.
What days do you have your trials on?
Fridays. We usually start Friday afternoon and go into Saturday if we're not finished on Friday. So you got any Saturdays you want to kill?
The only thing, so I'm available January the 5th, and I'm available December the 29th, December the 22nd.
Mr. Hill, do you have any input?
No, Your Honor, except just make sure that we don't try to put it on a day where we already have other contested things.
Mr. Dennison did just tell me that he's got a pretrial in common pleas or a divorce proceeding on January the 5th.
Okay.
December.
Oh, December the 5th?
Oh, he said January. Sorry, I already did January, sorry. I thought he said December.
Okay, so he's telling me January the 5th will work.
Okay. It's a pretty light docket right now. There is one trial, but I'm sure it's not a jury trial. We could probably either move it or get it resolved. So let's set it January 5th. Probably should have a pretrial. Like, there's always stuff that the lawyers don't talk about before, especially this far out. Lawyers are great procrastinators, folks, if you don't know that. So they put everything off to the last minute. So about a week out, we need to come back and talk.
Okay.
December 29th, we'll have a pretrial.
That's good.
At 10 o'clock.
Yep.
And then, it's not resolved, then a jury trial January the 5th at 1 p.m.
Oh, January 5th at 1. This is likely to be, I would say, one full day. I don't know if the court was serious or not, but if
Yeah,
we
we'll
don't,
come back on Saturday if it's not finished on Friday.
that would be my request, if we may, because I'll be out of the country on the 7th, which is Sunday.
Okay. Well, we'll do our best. January 5th at 1. I'd like to have any jury instructions that you want. I mean, if you don't give me any, that's fine. I'm just going to use OJI. If you got special jury instructions, please file them by December 29th so we can review and talk about them that day. If you don't submit any, then I'm going to assume you don't want it.
Standard OJI.
Other than what's standard.
Okay.
Anything else?
No, on December 29th, what was the time?
10 o'clock.
10.
Okay, that'll be the next hearing, December 29th, 10 o'clock.
Thank you.
State of Ohio versus Brittany D. Lively, case number TRC 23799 A and B.
This is Mr. McCown's case. It's set for a pretrial today.
That's correct, Your Honor. Did you want to approach?
Yes. So she went to file it. Okay. So she'll do it before. How long that will take. I'm not sure when they do theirs inside. Yeah, she can go anywhere. She doesn't have to go there. You want to do maybe 1st of February sometime? Yeah. All right, it's my understanding there's an agreement for a reduction if the defendant completes the driver intervention program. She can go to any program that's approved by the state of Ohio. I'm not sure exactly when that'll occur, so I'm going to give some leeway on the continuance, and then if you want to come back earlier, you can. Let's set it for February 2nd, if you're available then, Mr. McGowan.
If I could have one moment, Your Honor. It appears that I am here, Your Honor, yes.
Okay, February 2nd will be the next hearing. I'll set it as pretrial. So I understand there should be a plea entered then. If you want to advance it, just call the clerk and move it up on the docket.
Thank you, Your Honor.
You're welcome. There is time waiver till then.
Yes, we'll wait time, Your Honor. We'll fill that out.
State of Ohio versus Tracy M. Pauley, case number TRC 231600 A and B.
This is Mr. McCown's case set for a pretrial on a motion, as I understand it.
That's correct. May we approach very briefly, Your Honor?
Let me review the officer's statement.
Certainly, Your Honor.
finished it. It's my understanding there's a change of plea then.
That's correct, Your Honor.
What plea does she wish to enter?
No contest with stipulation finding of guilt.
Is that correct, Ms. Paula? Yes. You have a right to make a statement if you want before your sentence. You don't have to. Do you wish to say anything?
No.
Okay, I'll impose a $500 fine. Order you to pay the court costs, 20 days in jail, which I'll suspend, 6-month license suspension. That started the date of the offense. So, yeah, that's the correct date of the offense.
Your Honor, we would move, I think we already did this previously, I don't know if an entry went on, but we would have for continued driving privileges.
She wants limited driving privileges then?
Yes.
Okay. She can have driving privileges for community service, to go to the driver intervention program, for employment. Is there other things she needs driving for?
Medical purposes?
No.
No, Your Honor.
Okay. There's 5 days of community service required, 2 years of probation. The only time you'll have to report is for your review hearing. So, but if you finish things, and I don't have a date up here for May 31st. May 31st is her review hearing date at 9 a.m. She finishes everything before then. She doesn't have to come in. It's a hearing to make sure people do what they're ordered to do. Let's see, she also had a turn signal, $10 fine.
Thank you, Your Honor.
She's to see Mr. Major in probation, and then she's free to leave after that.
Thank you, Your Honor.
Okay, thank you.
State of Ohio versus Joseph M. Cremings, number CRB 22658 and CRB 22655.
Mr. Smith's case.
It is, Your Honor. Yeah, I'm going to try to dismiss
Yeah, that's fine. You guys are good response. All right.
Good report.
It is, Judge. I spoke with my client and the provider and Mr. Kameen's family as well, I think, and Mr. Hill. I think we're at the point now that it's right to be dismissed. I think the state is going to make that recommendation. And I think Mr. Kameen's is well on his way to where he needs to be. He understands
This is a lifelong journey, but he's doing very, very well.
Well, that's especially from Mr. Cremines' brother, that he says that he's very happy with the progress that he's made, and he wants it to continue on forever, but he feels that the program that he's in and the charges before the court have reached their maximum amount. Well, maybe not the program, maybe he should continue in it, but as far as the court involvement, that we've done all we can do to help the situation. So we're okay to dismiss the charges today. We would ask for the payment of court costs.
With no objection, Judge. He'll gladly pay those, and he's going to continue, he tells me.
Okay, one court cost, so there's actually two files. There's one on each or one?
One court cost.
Okay. Put the court cost on $655.
Judge, he can pay that today.
All right, both cases will be dismissed, $658 and $655 with the payment of one court cost.
Thank you.
See the clerk.
I got to send your file. It might be a couple minutes, but they'll send it to the clerk's office. Oh, okay, you're pal. Okay, you're good. All right, see you.
State of Ohio versus Gage Henson, case number CRB 23702.
Is Mr. Scott's case set for pretrial?
That's correct, Judge.
Thank you, Judge. State and I discussed this case this morning. We think we have potential resolve. That would require this being kicked approximately 90 days. Mr. Henson would have to complete anger management class, no issues with the dismissal at that time.
Mr. Field?
We are in agreement with that, Your Honor, and we've spoken to our alleged victim about that, and she is in agreement also. At the end of this, assuming that he's successful in completing the anger management and there aren't any further problems, we would agree to a dismissal upon the payment of court costs.
Does he have an agency that he's picked for doing the counseling?
We can find one. I can advise him on that in between now and 90 days.
Well, I'd like to go ahead and get that set up. How do you pay for medical? Do you have medical?
Health insurance.
You have health insurance?
Yes, sir.
Is that through employment?
No.
You have Medicare?
Yeah.
He has Medicare, Judge.
Medicare or Medicaid?
I don't know.
Are you getting Social Security?
No.
Okay, so it's Medicaid. We can do, and you live in South Point, right?
Yes, sir. Yes.
Bethesda? Okay, I want you to speak to Taylor about getting that set up. She'll meet you out in the lobby.
Yep, talk to her.
We're going to come back in about 3 months and hopefully get that completed. So let's make it March 1st.
March 1st?
If you're available. Hold on. Oh. I didn't mean to go right then. All right, so the next hearing is going to be March 1st for pretrial at 10 o'clock. You got to complete the counseling and no further problems. And if that happens, then the case will be dismissed on payment of costs. Is that correct?
Yes, Your Honor. And I need a time waiver too, which I prepared for.
Now you can go.
Thank you.
You're up.
State of Ohio versus Monica Monique B. Brooks, case number CRB 23687.
This one's also line, Judge. Top of the state, we're still in the process of receiving shading discovery. So we'd ask to get this one out. If you want 2 weeks still.
Yes.
So it's probably going to be longer than that. Let me
think December 29th is my first available, Judge.
That works. December 29th will be the next hearing. For pretrial,
What time you said, Your Honor?
10 o'clock, December 29th.
See you then.
Thank you.
Thank you, Judge.
Okay, we've got some teleconferences to do with the jail, which will start now.
State of Ohio versus Lisa Ann Adams, case number CRA 23721, A and B. This is Orange County Jail.
Okay, we need the jail to come online. Lisa Adams.
I just got a message back from the jail, Mr. Rob, is not there, he's going to be called the jail. He's not there, so he may take it.
Okay.
I just talked to them on the phone. They're in process.
Okay. While we wait on Miss Adams, we'll go to something else while she gets on the screen.
State of Ohio versus Jalen Forsythe. Case number CRB 198583.
This is Mr. Stratton's case set for pretrial.
Your Honor, we just asked this be set for another pretrial. I still need to request a discovery that I had not done, that I need to do from the prosecutor. Sign a time waiver. We could possibly set it for the 26th. Sounds like it might be a light day that day.
Yes. All right. At the finished request, case is continued to December 26th for a pretrial at 10 o'clock.
Thank you. Good.
All right, ma'am, are you, okay, she didn't have it.
Oh, sorry, Judge, if I was ahead of you there. Did you need her to stay?
No.
Okay, you're good, okay.
All right, this Lisa Ann Adams. It's showing it's muted on her end. Okay. All right, Ms. Adams, can you hear me? Okay, and you are Lisa Adams?
Yes.
All right, Ms. Adams, I'm Judge Capper at the Lawrence County Municipal Court located in Chesapeake, Ohio. Your arraignment hearing is taking place here in the courtroom where you are appearing on a monitor. So your image and what you say and what I say is all being recorded. Do you understand that?
Yes.
So what you say can be used against you. You don't have to say anything. You have a right to remain silent. You have a right to have an attorney, to have one appointed to represent you if you can't afford one. You have a right to have bail and to make the state prove. There's two charges. Those charges that are filed against you beyond a reasonable doubt. Do you understand these things?
Yes.
You're charged with aggravated possession of drugs and possession of a fentanyl-related compound. So the aggravated possession is case number 721A. It alleges that on November 30th in Union Township, you knowingly were in possession of methamphetamine, which is a scheduled substance, and that you had 4.3 grams of that substance in your possession. A felony 3 carries a maximum penalty of 5 years in jail and an $8,000 fine. Do you understand that?
Yes.
The B case, 721B, alleges possession of a fentanyl-related compound, and it alleges the same date, November 30th, you knowingly had in your possession a substance that contained fentanyl. That's a felony 5, maximum penalty is a year in jail, $2,500 fine. Do you understand that charge?
Yes.
Do you have the money to hire a lawyer?
I don't have money right now, but I do want a lawyer.
Okay, I can appoint a lawyer for you. You want me to appoint a lawyer to represent you?
Yes.
I'll appoint Mr. Morford to represent you. He's here in the courtroom, so he's heard your arraignment and the charges that you have filed against you. I'm showing that you have Del Barton, West Virginia address. Is that correct?
Yes.
Is that your last address, or what's your last address?
That's where my home is. Yes.
87 Turner Road, Del Barton, West Virginia.
Yes.
What's the state's position on bond for Ms. Adams?
Well, the state would request a $5,000 cash and surety bond, but we'd be willing to listen to alternatives if Mr. Morford wants to speak with her.
Okay. I'm going to let your lawyer call down and talk to you, and then we'll have you back. Here's going to be the issue, bond, and from my experience, one of the things they're going to be looking at, and you don't have to respond to this until you talk to your lawyer, just so you can be thinking about it, is are you willing to go to treatment? And if you're willing to go, will you stay there and complete the program? Fentanyl, I'll just say this, you don't have to respond again. It's alleged you have fentanyl in your possession. I don't know if that's true or not. The state has to prove that. But what I do know is there's a lot of it in our community. And what I also know is it's deadly. And I know a lot of people are dying as a result of them being exposed to fentanyl. So that's something to think about. It may not be true in your case. But if it is true, or if you're around that substance and it might be ingesting it, it would be a great idea for you to get off of it and get clean and not be around it in the future. And this is an opportunity for you to do that. You'll have an opportunity perhaps to go to treatment. So Mr. Morford's going to call down. He's going to talk to you about these issues. I would look favorably upon you going to treatment if you so desire, and would make the bond easier for you to meet if you could go to treatment. But here's the other thing you need to know, and he'll explain this to you. You are charged with felonies. What does that mean? Those are the more serious criminal cases, whereas if you're convicted, you can go to prison. The other thing it means is, on a felony, all the states have entered into an agreement. So a felony warrant issued from Ohio is good in West Virginia. So running back to Del Barton's not going to do any good for you to avoid getting arrested on a felony warrant. It'll still be good there. You'll get picked up, then you have to be extradited. It just takes longer to get you back, but you'll be in custody in West Virginia than in Ohio. And there's no state that you can go to and hide out, because that warrant's going to be good any place, that not only in the United States, but most of the countries in the world, the warrant will be effective. So now's a good time, if there is an issue, to face up to it and do something about it and get clean. Enough said. Mr. Morford's going to come and talk to you, and then I'll have you back on later, and we'll discuss how we're going to go forward. This case will be recalled later in the docket. Thank you, Judge.
State of Ohio versus Christopher Adkins, case number CRA 23722, and Claude Allen is on that.
Yeah, see here.
Claude Allen is next, and this should be Christopher Adkins.
Yes, sir.
That's you, you're Christopher Adkins?
Yes, sir.
Mr. Adkins, I'm Judge Capper. I'm at the Lawrence County Municipal Court, which is in Chesapeake, Ohio. It's about 20 miles from you. I don't know, I see it. We've got another alleged West Virginia resident, so I don't know if that's correct. I've got Harts, West Virginia. Is that where you're from, sir?
That's where I'm from.
I've been there many times myself. My ex-wife is from Harts, West Virginia. Harts Creek.
Oh, I heard that.
More particularly Dry Branch. Do you know where Dry Branch is?
Sure do.
Okay. Figured you might.
I'm from Big Ugly Road.
Okay. I see that. Big Ugly Road.
Yes, sir.
You've got a charge filed against you, case number 722. Well, let me explain your rights to you first. You have a right to remain silent. You don't have to say anything. But what you do say we're recording all this. You're on a television monitor in the courtroom, and it's all being recorded. So if you admit something about your case, the prosecutor could use that against you later. So you don't have to say anything if you don't want. You have a right to have an attorney, to have one appointed. If you can't afford one, you have a right to bail, to make the state prove this charge beyond a reasonable doubt. Do you understand those things?
Yes, sir.
The charge against you is aggravated possession of drugs. And it alleges that on November 30th in Union Township, you knowingly were in possession of methamphetamine. Methamphetamine is a controlled substance, and that you had a little less than 4 grams in your possession. So it's a felony of the 3rd degree. Maximum penalty is 5 years in jail and an $8,000 fine.
I didn't have that on me.
Okay. But you still need a lawyer then, because the states, they have to prove it, but they're saying that you did. So that's what they have to prove. Do you want a lawyer? Do you want to hire your own, or do you want me to appoint one for you?
You have one thing we're doing.
Do you have a job?
Yeah, I work for the ag logging.
Are you paid by the hour?
Yeah.
How much per hour?
I think it's like $10.50 an hour.
$10.50?
Yeah.
Wow, that's not much to do logging, is it?
It's not.
I would think that's kind of dangerous work, logging. Okay, well, you qualify, if you're making $10.50 an hour, you qualify for a court-appointed lawyer. And let's see. Tyler Smith?
What's that?
I'm getting you a lawyer. I'm rounding up a lawyer for you right now. And he's a West Virginia guy too, so, although not a WU guy, I don't think.
No.
Okay, good. He does not like WU, so, sorry, if you like WU.
My wife went there, but I did not.
So anyway, Tyler Smith's gonna be your lawyer. He's got a F3 possession charge.
Okay.
He's from Big Ugly, Hartsville.
Oh, okay. It's like old home week.
Yeah. So, we gotta figure out what we're gonna do on bond. Now, he blurted it out. One thing he did blurt out was, he didn't have anything in his possession, so he did say,
Okay.
deny it. What's the state's position on bond for Mr. Atkins?
Similar to the young lady that was just before the court, we would ask for a $5,000 cash and surety bond, but we would ask that maybe Mr. Smith speak with him and present another alternative.
I think you understand what that means?
Yes.
Maybe treatment? Okay, so I'm gonna let your lawyer call down, talk to you, then we'll come back, talk about your bond. Be thinking about, although you say you didn't have it, sometimes we let people out to go to treatment, if that's what Mr. Smith talked to you about. So we'll finalize the terms of bond after you talk to your lawyer. So I'll have you back after that happens. So, yeah, he's gonna talk to you on the phone, then you'll come back in front of me after you talk to your lawyer.
State of Ohio versus Claude D. Allen. And Shannon Badalamenti is on deck.
Claude Allen. $23,714. All right, sir, are you Claude D. Allen?
Yes, sir.
Mr. Allen, I'm Judge Capper at the Lawrence County Municipal Court. There's an allegation. Well, let me first tell you your rights. You don't have to say anything. You have a right to remain silent. If you do choose to say things, it's all being recorded. It can be used against you if you admit something that helps the state. They can use that. You have a right to have an attorney, to have one appointed if you can't afford one, and to have bond and to make the state prove this charge beyond a reasonable doubt. And what this is about, it's not really a charge in this court, it's alleged that there's a warrant for you in Washington County, Ohio, that's Marietta, from the Common Pleas Court there. And they're saying they want you to be returned to that court. So you have a right to what's called an extradition hearing, or I'm sorry, a Rule 4 hearing. It would be extradition if it was out of state. A Rule 4 hearing, anytime you're in a county that is removed from the county you're located, and you have a right to have a hearing to make sure we're not sending the wrong person someplace they don't want to go. And you can have a right, you have a right to have an attorney appointed to represent you. You understand what's happening?
Yes, sir.
And do you want to have that Rule 4 hearing? You can waive that and say, no, I agree it's me and I want to go back to Washington County and face this. You want to do that, or you want to have a hearing here about whether you're the right person?
I'm the right person. I'll go back to Washington County.
Okay. Then I'm going to send something to you that's alleging you violated terms of your community control in Washington County.
Okay.
I'm looking to see if they ask for a particular bond amount. It does not say that, it just says they will pick you up anywhere in the United States. So, I'm going to set bond at $10,000. Cash or surety. Is that a bond you think you could post?
No, sir.
Okay. So I'm going to order Washington County to pick you up before next Friday. So the sheriff's listening in, you can go ahead and tell them he's available to be picked up before 8 a.m. on December 8th. And if you're still in the jail, which hopefully you won't be next Friday, then I'll see you again like this on a hearing to decide what went wrong, because you should be in Marietta by then.
Okay.
But sometimes things go wrong, so that's why I don't always do this, because I don't want you sitting in the back of the jail and nobody knows what's going on. So I'll keep track of you. You should be in Marietta by then. If not, you'll be on my docket December the 8th at 10 o'clock.
All right.
We're going to send a piece of paper down for you to sign that's saying you waive the right to have a hearing and you agree to go to Washington County.
Okay.
Any questions you have, sir?
No, sir.
Okay, good luck to you.
State of Ohio versus Tiffany Gonzalez, case number CRB 23718. Shannon Badalamente will be called later in the docket. James Hall is on deck.
Okay, Tiffany Gonzalez now. Hall next.
And James Hall.
James Hall next. Ma'am, are you Tiffany Gonzalez?
Yes.
Ms. Gonzalez, I'm Judge Capper at the Lawrence County Municipal Court in Chesapeake.
Yes, sir.
We're doing your arraignment hearing today. In the court, you're appearing by teleconference, and your image and audio is all being recorded. You have a right to remain silent. You don't have to say anything. If you do say things, what you say is on the record. It could be used against you if you admitted something about your case. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, and to make the state prove charges beyond a reasonable doubt. You understand those things?
Yes, I understand.
You're charged with a theft offense from Walmart in South Point. It's alleged November 27th of this year. You tried to deprive Walmart of property without their consent. It's a first-degree misdemeanor. Maximum penalty is 6 months in jail, $1,000 fine. Do you understand this charge?
Yes, sir.
Do you understand your rights?
Yes, sir.
How do you wish to plead to this charge? You can plead guilty, not guilty, no contest. Those are your three choices.
No content.
If you enter a no contest plea, what you're saying is you're not admitting you're guilty, but you don't want to fight it either. And you agree that if I think what the state says it has as evidence is enough to convict you, that I can find you guilty without having a trial, without having a lawyer represent you. So,
Okay, so can I get an attorney appointed?
well, then we need to enter a not guilty plea. So I'll enter a not guilty plea for you.
Okay, thank you. I'm sorry, sir.
No problem. I'll appoint well, I have to ask you about your income. Do you have a job?
No, not at this time. I was about to go to work in Moorhead. I was supposed to start Monday, so.
What kind of work were you going to do?
At the Whiskey Barrel Factory in Moorhead.
Doing what?
It's just factory work.
How much were you going to get paid?
Well, it's supposed to start at $19 an hour, but I didn't even get a start, so.
That was last Monday or this coming Monday?
Well, this coming Monday.
Okay, I'll appoint Mr. Stratton to represent you. Can you post any kind of bond, ma'am?
No, sir, I can't get a hold of no one. I don't have no phone numbers.
No, so you don't know, you've got people to call, but you don't know their phone number.
Well, I really don't have no one to call, honestly.
You don't have any family or anybody that could post a bond for you?
No.
Just got an Olive, Kentucky address?
Yes, sir.
I've got connections with Olive too, but I won't go into that. My mom's family, the Skaggs. There's a few Skaggs around Olive Hill, isn't there? Have you ever heard of any Skaggs?
Guys, yeah.
Yeah, they're people to stay away from, aren't they?
Yes, most definitely. Most definitely.
They like to drink and fight.
Most definitely like to fight.
Scots Irish.
Your Honor, I asked that she be allowed to sign her own bond on this.
Well, I hate for her to miss out on a $19 an hour job.
Yeah.
She can get it.
Absolutely, yes, they're still kind of like.
Will you at least promise me you'll come to court if I let you out on a signature bond?
I promise you, sir, you have no problems. I mean, got no worries there, I will be back.
Your Honor, we want to make sure that we got the spelling right on her last name because it came to us in the report with that spelling, but it just doesn't look right to me.
It's Gonzalez.
Easy. So we moved to amend that last A to an E.
No objection.
All right, they had it on the paperwork spelled wrong, so I'm amending it to the correct spelling.
Okay.
With an easy at the end rather than AZ.
Yes, it's easy.
All right, ma'am. Do you know your own phone number? Do you have a phone number where Mr. Stratton, your lawyer, can reach you?
Yes, and my phone's in my property. It is 606-240-8044.
All right, Kevin.
All right, so when do you want to come back?
It's up to the court.
Well, you're going to have to tell your new employer you got to have a day off to come to court. December 29th?
Yes, that's fine, Your Honor.
That's a Friday. In fact, I would, if you want to talk to her about it, I would let her appear by teleconference if she wants.
Okay.
For that first hearing.
So I can appear online?
Yes,
Oh, that would be awesome.
at least initially, and Mr. Stratton can give you the information on how you can do that.
Yes.
Okay, okay.
And Your Honor, it looks like she's been in jail. This is her third day in jail, so, you know, if and when she enters a guilty plea, we would want that considered as a big part of the consequences for this.
All right. I'm going to let you sign a $2,000 signature bond, ma'am. So as long as you come to court, you won't have to pay anything. If you don't come back to court, I'm going to issue a warrant for your arrest, and you have to pay $2,000 once you're arrested for not appearing.
All right, thank you, Your Honor.
You're welcome.
Approach, Your Honor.
Yes.
On this case?
I guess we're done.
I just have to be back on 145. But we're going to call you next.
I got it.
They're going to dismiss, but they want you on the...
Kevin Dennison here.
We'll have a slight delay at the Lawrence County Jail. Here at the court, we're calling Richard Dennison, State of Ohio versus Richard Dennison, case number CRB 23-543, A and B.
Mr. Morford is the attorney for Richard Dennison.
James Hall is on deck at the Lawrence County Jail.
Ms. Gonzalez, you can step aside, and we need Mr. Hall in your place.
Okay.
All right, and it's my understanding the state's going to is presenting a motion today.
Yes. Your Honor, I have the son of the victim here, Kevin Treadway, and we've discussed this matter. And this was a very unfortunate situation. It took place in the parking lot at Walmart in South Point. And the gentleman, Mr. Dennison, was backing out of the parking place and struck the lady and caused her to fall, and then subsequently she passed away from injuries. The primary concern that we had until we got the video was that Mr. Dennison left the scene. He did not. The video shows that he stayed around and the EMS came and, you know, and subsequently, I think after Mr. Treadway came to understand that he did not leave, his feeling was the same as, and it's understandable that it was one of those things that could just very well happen to anyone. We didn't see any recklessness on this individual's part at all. So for that reason, we are okay with the dismissal of this charge. And I wanted to have Mr. Treadway here, of course, to let the court know that himself.
All right, Mr. Treadway, anything you wish to say?
No, just what he
You
said.
agree with him?
Yes, sir.
With what Mr. Hill represented. Mr. Dennison is not here today because I understand he's ill, but I'm assuming that Mr. Morford is a lawyer. You have no objection to the state dismissing the charges.
Judge, you've taught me when to be quiet.
Okay. Case will be dismissed.
Thank you, Your Honor.
Thank you, Your Honor.
Appreciate it.
State of Ohio versus James Hall at the Lawrence County Jail, case number CRB 09237. Christina Markham is on deck.
All right, James Hall, is that you, sir? Are you James Hall? Can you hear me, sir? Okay, your audio's turned off there. I can see you moving your lips. Nothing's coming through. So usually it's something on the headset. I think there's a switch they have to flip. Okay, now try it. Can you hear me, sir?
Yes, sir.
Okay, very good. It's alleged, Mr. Hall, that you missed a hearing in this court, it's been some time ago. Back in September of 2009, you had a review hearing on a theft conviction, it's alleged, from Walmart, failed to appear, got a warrant issued, and I guess that warrant kicked in here recently, and you're in custody because of it. Do you understand the charge, sir?
Yes, I do.
Do you admit or deny that you missed this hearing and that it was you that had the theft offense?
Yes.
Do you admit it or deny it?
I did.
Do you have an explanation why you didn't come to court and didn't do what you were ordered to do back in 2009?
This family thing.
I didn't understand what you said, sir.
This kind of, just get the family around.
Okay, how did you get arrested on the warrant?
There was somebody at OE, and I stayed there to help them. That's the reason why I had a,
They checked you and you had a warrant.
yes, sir.
How long you been in jail now?
A couple days.
You still live in Ashland?
I'm just staying over here.
You're in Ohio now?
Yes, sir.
Well, you had a 10-day jail sentence, which was suspended if you did some community service and paid a fine. You never did any of that. Do you want to serve out the jail sentence, or do you want to do the community service now?
Can I do community service?
Yeah, if you will you?
Yes, sir.
And where are you living? What's your current address?
I just moved in. It's off 6th Street. I just moved in.
It's in Ironton?
Yes, sir.
6th Street, Ironton?
Yes.
Is that south, whatever?
South, yes,
South 6th
south.
Street?
Yes.
Who are you living with?
I'm living by myself.
Oh, you're by yourself?
Yes.
Do you have a job or anything there?
I'm retired.
Okay, well, here's what I'm going to do. I'll send you to time served for contempt for not coming to court back when you were supposed to, and just reinstate you. So the way this is going to work, I'm going to give you another review hearing date.
Okay.
You got to get this stuff done. What you got left, you got $292.50 that you owe for fines, court costs, and you got a $50 fee there for missing your last hearing. You've got 5 days of community service to do.
Okay.
If you get all that done, then we're good. If you don't do it, and you don't come to court again, you'll get another warrant.
Okay.
You understand?
Yes, I do.
And you know where the court is that you've got to come to?
Yes.
In Chesapeake on County Road 1.
Okay.
Old 52.
Yes.
Okay. So I'll give you a review hearing date of January 29th, so the last Monday in January.
Okay.
Last Monday in January, you've got to come to the court for a hearing at 9 a.m. unless you've done everything by then. If you've paid your fine and court costs off and done your community service by then, you don't have to show up. If you don't show up and you've got stuff left to do, we're going to go through this again. I'll issue a warrant for you and it'll hang out there probably until you get police contact again.
Okay.
So just take care of it and you won't have to worry about it anymore.
Yes, sir.
Any questions, sir?
No, sir.
Okay, that's all. You get out there and as soon as we get the paperwork down.
All right, thank you.
You're welcome.
State of Ohio versus Christina Markham, case number CRB 23720. And Christopher McGee is on deck.
Christina Markham, let's who should be coming up next. Okay.
State of Ohio recalls Chastity Sackman here at the court. Chastity Sackman.
Tyler Smith is her. Chastity Seckman, come into court.
Chastity, second.
Tyler Smith, come into court. Okay, I'll pass this one.
Your Honor.
Oh, there's Tyler Smith.
I was on hold on with the jail, Your Honor, sorry about this.
Okay. Come up and look at her, got her screen result. So, it's not working.
I see.
I knew it was gonna be that way.
Okay, well, you tested positive for the very thing you're charged with.
Yeah.
And the other most common drug that's in our community, methamphetamine. And fentanyl, to be clear. Tested for both of this, so, and I don't have anything. Here's the thing. You're in this court now, which is the misdemeanor court. I couldn't send you to prison if I wanted to. If I drafted an order ordering you to go to prison and sent you up to the prison, they're not going to take you because I don't have the authority to send you to prison. You understand that? But you've charged with a felony. What does that mean? We're just holding you here for a while to let you go to treatment. If it doesn't work out, you're going to go, first of all, your case will go in front of a grand jury, which is kind of mysterious because they meet in secret. There's just a bunch of people in the community that meet in secret. The prosecutor goes in there and tells them what they've got as evidence, and then they issue something called an indictment. You know, a felony's so serious you got to be indicted. They can't just trust the prosecutor to file the charge. People in the community got to say, yeah, this person needs charged. That's a rubber stamp, like an indictment. It's been a lot in the news lately. It's really serious stuff.
I'm aware.
Then you can go to prison if you have an indictment. And I'll be out of the picture. You won't be coming here anymore. You're going to go to the felony court. And if the judge there issues an order you go to prison, guess what? They're going to take you to prison. So that's the negative side. So you got a lot to be scared about. I would be scared. I'd be scared to go to the county jail.
More than you realize.
I'd be even more scared to go to prison. There's a tougher group of people at prison than there is in the county jail generally. So you don't want to go there and hang out. On the positive side, you've got resources available to you to get clean. Take advantage of it. Now, I don't know if you've been to ProAct or not, because I have nothing from them showing that you're there. But if you're going, it's not working because you're testing for the very...
I didn't test positive yesterday.
Well, you tested positive here today, and I'm going to believe the test because we've been doing this for a long time.
No, I
and they
understand.
seem pretty accurate. So I'm going to give you, unless the state wants to harp and say, no, send her on to the grand jury now, I'm going to give you another chance. But at some point, I'm going to just say, no more chances. Go on down to the common police court, get indicted, and take your chances down there, where you've got a pretty good chance of winding up either going to STAR or going to prison. And neither of them's like going to ProAct, because you know if you go to STAR, what that's like? It's like it's like halfway between prison and, because it's a lockdown. You go there, they got barbed wire on the fence. There's no freedom for you. You're going to treatment every day, and they make you go, and they're standing over you 24/7, even while you're sleeping. Somebody's watching you. Do you want that?
No.
Are you scared?
I mean...
I'd be scared.
I'm scared.
Scared enough to change your behavior? You got to change.
There's other things that I'm more scared of. Like my daughter. I'm more scared about my daughter.
Well, such as missing out on being around her. If you get sent to STAR, your daughter's not going to go with you. If you get sent to prison, your daughter's not going to go with you. And you being out of her life, how old's your daughter?
She's 7.
7. Ooh. Ever heard of adverse childhood experiences? Your mom going to lockdown is an adverse childhood experience, and that's one of the things that's not good for kids. And if you want her to wind up where you are, keep doing what you're doing, because you're making the chances higher. We know that from studies. You keep using, that doesn't guarantee she's going to use, but it makes the odds higher that she's going to use. Do you want that?
It's not an everyday thing. No, I don't want it at all. No. I don't
It
want
doesn't
that.
matter if it's an everyday thing. Fentanyl is killing people. Do you understand that? It only takes once. You get the wrong dose,
I'm not even sure where that
you're
came
out.
from.
And then there's another adverse childhood experience. 7 years old, you don't have a mother. Your mother's dead. That's a pretty big adverse childhood experience. You got a lot of reasons to get, I'm trying to give you some negative reasons and some positive reasons. You need to take this serious. You're not taking it serious yet. Am I wrong? I don't think I'm wrong.
When I went into PRO Act, I made sure that I was clean.
Well, that's not helping.
It's stupid.
That's not
I
helping.
know, it's stupid.
And you weren't, obviously, you probably weren't honest with them about your usage either, were you?
I was, yeah.
Kinda.
Kinda.
Because I get people that go and they'll say, well, I don't really know, the judge said I had to be here, I'm not really using. And then what are they gonna do? They have to take what you give them as a history.
I understand.
Did you tell me that you're charged with a felony, that you could go to prison, that you're charged with possession of fentanyl-related compounds? That's what you need to tell them.
I did.
Okay, we're gonna try this again, Les. Are you ready to give her another chance?
Yes, Your Honor, but I would like to know a couple things. First of all, I'm not sure if this was the individual who previously it was said that they said she didn't need treatment. Was that this case?
She went to PRO Act and she tested clean.
So we would, obviously it may be that there needs to be a different provider. That would be number one. Number two, we also have a theft charge, which we are happy to extend the opportunity to Ms. Seckman to go through treatment on the felony charge and then not take it to the grand jury and even dismiss the charge when she's successful in completing her treatment and showing that she's going to stay clean. But on the theft charge, that has to be resolved with either a plea or a trial.
Depends on what they assess you for. They could start out that way if you have any trouble.
You need some time to talk, or you want to?
No, do you understand?
No, I was just asking about outpatient treatment.
I told her that it's based on how they assess her with the treatment facility.
I'm willing, maybe I shouldn't say this out loud, but people that have jobs and people that have got kids that are little and they're still taken care of, I kind of bend over backwards to try to help them stay outpatient. But at some point, there are programs where you can go and take her with you, and that may have to be the next step if you can't get this going. Is that you only have the one child?
Yeah.
Are you the sole parent? Is there anybody else in the picture that's helping with her?
Her dad's in jail.
Okay. And you're in Lavallette. Is that the right?
Yeah.
Is that right? This is a West Virginia day. We've had tons of people from West Virginia today. Which is not that unusual. But does OVP have anything in Lavallette yet? You will eventually.
No, we have an outpatient office in Huntington.
I could do that. That's fine.
I can
Okay.
talk to her if you want.
Okay, I'm going to have you talk to Ms. DeMint from OVP. You have a West Virginia Medicaid card?
Yeah.
They can treat
I don't have
you.
the card with me, but I do have one, yes.
Okay. All right, so this next phase, you're not going to be attempting to game the system. You're going to be attempting to take it serious and go in there and tell them, I want to get clean. You tell me, and let's work together what we got to do for me to get clean for myself and my daughter, right? Not how I kind of go in here, game the system, you come back, what do you think? They're going to come back and say, oh, she's clean, she doesn't need any treatment. That's not going to happen. And then you can use on the days when you don't think you're going to get screened. Okay, so speak to Ms. Dement from OVP, get in there, get some treatment, get clean, quit hanging out with the people that are using, whoever those people are. Do it for your kid and for you. And let's get serious about this. How about 2 weeks, the 15th?
I'm not available the 15th. I am the 18th, though, Your Honor.
Okay, I'm trying to keep the 18th light, but we'll make an exception here.
Okay.
December 18th.
December 18th.
10 a.m.
So we'll want an answer on that day as to whether she wants to plead guilty or wants a trial.
On a theft offense.
Yes.
Okay.
All right, thank you, Your Honor.
See Ms. Dement, then you're free to go. Okay, so we've got Christina Markham on the screen. Are you Christina Markham?
Yes, sir.
Ms. Markham, I'm Judge Capper at the Lawrence County Municipal Court in Chesapeake. This is your arraignment hearing. You're hearing in court on a television screen, and it's all the audio and the visuals all being recorded. So if you say something that hurts your case, the prosecutor can use that against you. You understand that? You don't have to say anything. You can remain silent if you wish. You have that right. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to bail and to make the state prove charges beyond a reasonable doubt. Do you understand those things?
Sir.
The charge against you is criminal damaging. It's alleged that on November 28th in Fayette Township, you knowingly caused or created a risk of harm to the property of Diana McMillan, and that you did so without her consent. So that is a first-degree misdemeanor. I'm sorry, it's a second-degree misdemeanor. Maximum penalty for a second-degree misdemeanor is 90 days in jail, $750 fine. Do you understand the charge?
Yes, sir.
Any questions before you enter a plea?
Yes, sir.
How do you wish to plead to this charge?
Not guilty?
Do you want a lawyer appointed to represent you?
Yes, sir.
I'm sorry, I didn't understand what you said.
Yes, sir.
Do you have a job?
I clean houses,
What do you make in an average week?
between 80 and 150 to 200 a week.
Okay, you're eligible for court-appointed counsel then.
Sir?
Been around the horn. So, Mr. Smith, I'll appoint you, Roger Smith. Your attorney is here in the courtroom, and he's been here during your arraignment, so he's heard the charges. I'm entering a not guilty plea for you. What's the state's position on bond for Ms. Markham? She has I have a South Point address for you, ma'am, is that right?
Yes, sir.
Your Honor, we very easily could have charged this as a burglary, first of all. That's number one. But in having discussed this matter with the manager of the property where this took place, it's a rental property, and then also the occupant of the property, we determined that it was appropriate at this time to file it as a criminal damaging, but we also want the court to know that we're told that this was the result of some serious substance abuse issues, that this was a matter of maybe her not being fully about herself and understanding what she was doing at the time. So we think that there are substance abuse issues that need to be addressed, and if she's not willing to do that today, we'd ask for a cash surety bond of $5,000.
You want to talk to her?
If I could, Judge, borrow the court file and call down there, I would be glad to do that.
I'm going to let your lawyer call down and talk to you off camera, so I won't be And everybody in the courtroom, when there's a lot of people, they're all listening to what you say now. So if he's not call and talk to you, then we'll come back and decide what your bond is. One of the things I hear, though, is treatment. They're going to ask, the state's asking that you go to substance use treatment. So you don't have to say anything now, but talk to your lawyer about it. We'll decide how to go forward later in the docket.
State of Ohio versus Christopher L. McGee, case number CRA 23717, CRB 23696, CRB 23683. Shannon Badalamenti is on that.
Approach on this? I don't know, what do we need to approach? I mean, well, this is the initial appearance on the felony, so it'll get set for preliminary, and we'll decide between now and then.
Okay, all right, we'll do that. And what did you want to approach and talk about?
He also, well, I don't care.
This is Christopher McGee. Is he at the jail?
Yes.
Okay. 23717, and then there's also 23694 and 23683.
This is
He's homeless and came here from South Carolina and all the way to, rather than go to the Walmart for about 60 or 70 miles away from here. It's a shock there.
So there's definitely not about 5 minutes should be on and I believe possibly have to decide what they want to do with
Yes. 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 Kenny Clean Hardware tried to get stuff to take the ankle monitor off. Yes. Yes. They don't like it when people That's what I remember I said at Arraignment, they saved him like 3 years in prison by snapping for the theft. You want to keep it here to find that out? Or? Yeah. Today is Friday. Don't tell me it's Monday. My heart, I've been thinking it's Friday all day. One of the reasons I sent treatment to take a test, or he's with his wife, it's his wife. And she initially said she wanted to get a treatment, and she ran. I didn't put an ankle monitor on, I put one on him. It seemed like he either knew it was a serious problem or took a test. I think I sentenced him. All right, so Mr. McGee is here, is appearing in court by teleconference today. He has a new charge of vandalism. It's a felony. Appoint Mr. Stratton to represent him on that. That's just come up for arraignment. So there's discussions going on, Mr. McGee, between the state of Ohio and your lawyer as to what they want to do with you or agree to do with you. So your lawyer wants to keep it in this court for another week to let them look at some options as to what they want to do. Problem is, I let you go to treatment with an ankle monitor and you still tried to leave. So that kind of makes it hard to release you again with an ankle monitor, since you've already demonstrated once that you would try to leave even with an ankle monitor. So you don't have to say anything, but that's the issues. You're asking for a continuance for 1 week to let the state investigate some possibilities.
Yes, Your Honor. It might give them enough time where we can possibly figure something out that maybe get him out of jail sooner rather than later. So.
Okay, I'm going to set this for preliminary hearing on 23/7/17 for next Friday, December 8th. In the meantime, for clarity's sake, I'll set a $10,000 cash or surety bond in that case, and continue his other cases for pre-trials and review hearings for the 8th. So all of his cases are December the 8th now.
All right, thank you, Your Honor.
You're welcome.
State of Ohio versus Shannon Badlamenti, recall case CRA 23697.
It's Mr. Morford's case, preliminary hearing today. How do you wish to proceed, Mr. Morford?
Judge, when we spoke last week, she indicated a desire to go to treatment. Mr. Hill and I had discussed that as a possible way to at least start out towards a resolution. I don't think he's not made any promises to dismiss the case if he would successfully complete treatment, Judge. But Ms. Badlamenti, is that still your desire to go to treatment?
Yeah.
You have a medical card from what state?
Ohio.
She is charged with a fentanyl-related compound, so I would say she needs probably inpatient. But who's got female beds and who can do an assessment?
I'm on methadone, so I wanted to go to OD.
Oh, yeah, now I remember. So that's a big complicating factor.
How much methadone?
It was a lot.
200.
Over 200 milligrams a day. But you haven't been taking any methadone at the jail, I assume?
No, I haven't.
Did you have withdrawal?
Yeah.
We've got a lady, 200 milligrams of methadone a day, but she's been in the jail for probably a week now.
Yeah, I spoke to her last time, but she's the one that dipped her urine in this blood.
Oh,
We
yeah.
were going
now I
to take
remember.
her, but, so yeah, I'm sure we have a spot for her if she's willing to come to treatment.
Okay. So that dipping into the toilet bowl cost you, say, in jail an extra week. Are you sure you're ready to go to treatment and take it seriously and no games and try to get clean?
Yes,
Have you been to treatment before?
yes,
Where?
Procedural and elsewhere.
Inpatient?
Yeah,
How long ago?
it's been a couple of years.
Okay, well, let me make sure you understand how the ground lays here. You're charged with a felony, which means you can go to prison on a felony. You understand that, right? Not the county jail where you are now, to the big house. That's where you can go with a felony. Do you understand? Yeah, does that matter to you?
Yeah.
You should be scared of that. I would be scared of it. Scared enough to change some of your behaviors. And try to do good. Take treatment seriously. And do what they tell you to do, when they tell you to do it, how they tell you to do it. Without giving any guff to the people that work there and the other people that are in the program. Can you do that?
Yeah.
Because I got somebody back in the holding cell right now that can't, but didn't. It was causing a big uproar at the treatment facility she was at, so she's in custody right now. I'm not going to let you interfere with other people's recovery by your non-cooperation. Do you understand me?
Yes.
Okay. I'll order her released on a $2,000 signature bond to OVP for inpatient treatment.
And we do have a bed available for her, Your Honor, so as soon as
So they can
she's
pick her up
released,
today?
we can pick her up, yes.
And then let's come back for a report on December 15th. So I'm going to get a report on you in 2 weeks as to how you're doing. Make it a good one. Make it a good report. So you're available then?
Yes, Judge.
So it'll be on the docket as a preliminary hearing.
Thank you.
Okay, good luck, ma'am.
Thank you, Your Honor.
When are we coming back, Rich?
December 15th.
State of Ohio recalls Christopher Atkins at the Lawrence County Jail, case number CRA 23722. Christina Markham is on deck.
Christopher Atkins, this is my guy from Big Ugly.
Yes.
Hearts Creek. Are there as many Atkins in Lincoln County as there are in Wayne County?
I think, well, there probably is, I don't know.
It's a very common name.
Yeah, well, Wayne County is definitely very common.
Maynard, Ferguson, Napper.
Napper, yeah.
All right, Christopher Atkins is back in court after talking with his lawyer, Mr. Smith. We're going to discuss bond.
Yes, Ron, I spoke with Mr. Atkins. I believe his mother's here. She is in the process of calling Mr. Sowers to try to post his bond. I told her that it was the recommended bond that Mr. Hill proposed was $5,000 cash and surety, so he's going to try to post the bond.
Okay. I'll set bond at $5,000 cash or surety. We'll let, somebody's already contacted Mr. Sowers?
I believe so. I talked to his mother just a little bit ago. She was going to try to get in touch with him.
You're pretty sure they can post it then?
It's my understanding, yes.
When do you want to come back? The next hearing?
It can be within the next week or two. I'm just not here the 15th, so whatever.
Well, I mean, do you want to go beyond the time frames, or you want
We
to?
we can if he's going to be released, yes.
Well, let's see. The 8th or 11th, either one could work. Which one? The 8th is next Friday, the 11th is a week from Monday.
We can do the 8th.
Okay. Next hearing is December the 8th for a preliminary hearing at 10 o'clock.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Christina Markham, the Lawrence County Jail, case number CRB 23720 on the recall. Lisa Ann Adams is on deck.
This is Mr. Roger Smith's case, and the issue here is also bond.
Judge, I spoke with her. She believes she can make a $2,500 cash surety bond. It's an M2. I believe Mr. Hill's in agreement with that, and I will contact Mr. Sowers if the court is willing to make that her bond.
$2,500 cash or surety will be the bond.
Yes, sir.
And when would you like to come back?
I'm here the next 3 Fridays, or then I jump into January.
How about what's our time frame on a second degree misdemeanor?
To try it, it's still 90 days.
I'm here the next 3 Fridays, or the 8th or 16th of January.
January, you'll sign a time waiver?
Yeah, oh, yes, sir, absolutely, yes.
All right, January 8th.
Okay.
January 8th will be the next hearing.
This is Martha.
Yes,
For pretrial, 10 o'clock. Your next hearing, ma'am, is January 8th at the court of Chesapeake. You got contact information?
I do. I need her. What's your mother's I have yours. What's your mother's telephone number?
740-377-3376.
And what is her name?
Diana McMillan.
All right. Thank you.
Thank you very much.
I'll go with Mr. Sowers, Judge.
State of Ohio recalls Lisa Ann Adams at the Lawrence County Jail, case number CRA 23721, A and B.
Lisa Adams. And Mr. Morford, this is your case?
Yes, sir. When you appointed me to earlier and asked me to call down.
Yes.
Speak with Ms. Adams. She is interested in seeking treatment, Your Honor.
Okay, let's get her on the screen. Okay, we're in the air. Okay, let's go ahead and, while we're waiting on the jail, we've got some arraignments we can do, so we'll do the, well, here she is, she's back. All right, Miss Adams, can you hear me? Okay, you've talked with your lawyer? Correct?
Yes.
Okay. She's interested in treatment, I understand.
Is that correct? Ms. Adams, do you want to go to treatment?
I would like to pay the bond, but if I can't, then I will go to business.
Okay. Well, you want the chance to post bond?
Yes.
What, was it 5,000 you requested?
Yes, Your Honor.
Because it's a F3, I believe.
Yes.
All right, I'm going to set your bond at 5,000 cash or surety. Get a bail bondsman to talk to you. I'm going to put her back on the docket for Monday. And she doesn't have to be here if she's posted bond. She's still in the jail, then we'll decide then if maybe she'll be wanting to go to treatment then if she's still sitting in jail.
Really, her willingness to go to treatment is, and I understand we're kind of prejudging things, but this is a case that could easily go to the grand jury. So that should maybe be something she should factor in.
Okay. on the docket for Monday, but there will not be an evidentiary hearing, just to make clear. It's just really on the status of bond. So if she's still in the jail, I'll deal with her. If she's not, then I'll schedule another date for her to appear.
Thank you, Judge.
Can my attorney call me?
I didn't understand what you said, ma'am.
Can my attorney call me again?
He can. He's free to call you. She wants you to call her.
Okay.
That finishes up at the jail.
State of Ohio versus Ryan T. Evans, case number CRB 23723, CRC 231777, A and B.
Mr. McCown's case, and I believe this is for arraignment.
That's correct, Your Honor.
Do you waive a reading?
We do, Your Honor. I believe they filed additional charges as well, so there's an
Yes,
additional.
23723, 231777. So,
We did enter not guilty pleas on all of the charges, Your Honor.
not guilty is entered. Do you have a preference as to hearing date?
Your Honor, previously, the state had indicated they would agree to a stay of the ALS in 1777. He's out of state and it's required for his employment. So I think that'll, whatever the court's position on that would be, and we can address the court, I think that would impact kind of how we do it. If the court's inclined to grant that, then we have no objection. We can set it whenever the court wants. We'll wait time.
Okay, well, if the state's agreed to it, I'm okay with it staying.
Wasn't there a basis because of the timeliness of the filing?
They didn't file it for 5 days after.
Apparently, there's a rule or regulation or law that says that something has to be filed with the court within a certain amount of time.
Okay, I'll stay the ALS. So we're looking for a pretrial. I'm looking at the last week of December, the 26th, 29th, or into January.
If I could have just a moment, Your Honor. I don't believe I can do the 29th. I'll be out of, unfortunately, I am out.
Pretty much any date in January works.
Whatever's easier for you, doesn't matter to me.
And then the court's scheduled a bunch for the 5th, I think, even including a trial. Do you want to do the 12th or?
12th's fine.
Okay.
January 12th will be the next hearing, 10 o'clock for pretrial.
Thank you, Your Honor.
Thank you.
State of Ohio versus Kevin L. Sykes, case number CRA 23239.
All right, you are Kevin Seitz. Mr. Seitz states alleging in case number 239 that on October 1st, this is an old case, 2022, you deprived Thomas K. of property, being a 7x18 trailer without his consent, value being more than $1,000. So it makes it a felony 5 theft. Maximum penalty is a year in jail, $2,500 fine. You understand the charge?
Yes, Your Honor.
You understand your rights?
Yes.
Do you wish to be considered for court-appointed counsel?
Yes, sir.
Do you have counsel?
I can get.
How much time do you need to make that happen?
Well, it looks like you're pretty busy in December. I'll take.
We're always busy.
Whenever's convenient for you all.
Okay, well, you have a right to have a hearing within 15 days, but you can go longer if you want to waive it. It's your right to have that hearing in that time frame. If you want to go longer.
I'll wait till January sometime if that's convenient for you guys.
Yes. Let's make it January 8th. January 8th, that'll be a preliminary hearing. At 10 o'clock, I'm putting down to hire a lawyer. He can sign a $2,000 signature bond since he appeared on his own.
We also need him to sign the time waiver.
Okay, you're just signing something agreeing that you agree that it go longer than 15 days before the next hearing.
Yes, sir.
Be back here January the 8th, 10 o'clock.
Thank you, Your Honor.
You're welcome.
Thank you.
You're welcome.
State of Ohio versus Bruce Maynard, case number CRB 23710 and TRC 231013 A and B.
All right, Mr. Maynard is here. He had been at Hope, was it Hope Source where he'd been?
Yes.
And he left treatment? Okay, any other information you want to impart to the court about that?
He left the Hope Source Tuesday night, Wednesday night. And we sent a message that this ASA said it was something wrong.
He'd been at Bethesda before, outpatient, and I think that was not too well.
We were in contact with him yesterday and offered him to come back in. We thought we had something arranged, but we did not show.
And this actually, on the file, it's designated CRB case number, but it's actually a CRA. Should be CRA 23710. Is it filed as a CRA? It should be a CRA. Yeah, he hasn't been arraigned on it yet. He's got a possession of cocaine. That's all that's all. It should be, should be amended to a CRA case. Felonies are CRA, misdemeanors are CRB.
You got possession of cocaine card, charge now.
Yeah, are you in receipt of that charge, Mr. Moulton?
Your Honor, I am.
Okay.
Yes, I just.
Okay. You want me to read it into the record?
No, we waive reading, Your Honor.
Is there an explanation for him leaving treatment? Let me put it this way. Is there a good explanation for him leaving treatment?
I'll let you pass judgment on that, Judge. You want to tell him what?
Yes, sir, I'd only seen my counselor one time down there. In the, 11, 12 days I was down there. I'd only seen my counselor one time. There's no really structure down there. You get up, you go to bed, you get up, go downstairs, you sit around and you just talk. And then you either go to the gym or something like that. The only thing you really get out of it is of the evenings when you get to go to meetings.
Okay. Any response?
Well, treatment, it's inpatient, you get up, you go to do.
And when did you get, do you have any kind of written report on this? Or?
Yeah, we faxed it to him. I don't have it with me because I didn't expect him to be here today.
I don't have it.
No, we faxed it to your
probation officer?
Yeah.
Okay. Let me get that report and review it, and then you discuss further with Mr. Maynard. We'll recall it later.
Thank you, Judge.
You're welcome.
State of Ohio versus William K. Elkins Jr. for the third, case number CRB 23347. Mr. Morford, this is your case.
Set for pre-trial today.
Can I approach the bench with the...
Give it to your lawyer.
And he's supposed to be bringing that on Monday. Position of KK. So he's just doing treatment.
Mr. Capper, your microphone that leads out to the PA system out there is kind of quiet. When I was out there earlier, we could barely hear you. Just figured I'd let you all know that before somebody misses their hearing because they couldn't hear being caught out there.
They're supposed to be in the courtroom.
Fair enough.
Okay, looks like his good report, he's done what he needs to be doing. How does the state want to proceed?
Well, Your Honor, I'm looking here, it looks to me like every one of his reports has shown some progress, which is a good thing. The victim of this is Mr. Elkins' father, and his concern has been for him to get his treatment and not necessarily to seek a conviction. At some point, I guess this is probably a situation where Mr. Elkins is going to need to commit himself to continue with this forever to make sure that he keeps from getting back into situations again. And, I don't know whether this is the appropriate time to say that we've gone as far as we can. It certainly he's built up a record of compliance. So, since June, I guess I need to say what I want to do.
He didn't go up the deep end when his house burned to the ground either, which would be a considerable stressor.
Yeah, I think he's shown a pretty good commitment to his own well-being, which is what we wanted. So we would not oppose a dismissal of the charges at this time.
Case will be dismissed and closed. No court cost.
Thank you. Thank you, Your Honor.
Well, congratulations, sir.
Mr. Capper, did you say that no court cost? Or?
Correct, no court cost.
Thank you, sir.
Your Honor.
State of Ohio recalls Bruce Maynard, case number CRB 23710 and TRC 231013 A and B.
Okay, I have the report now from Hope Shores. Okay, they're saying that initially you offered to come back and then that never happened.
Excuse me?
They're saying that you initially said you would come back, but you didn't come back.
I was asking also, Your Honor, I said, because one of the counselors led me to believe also that they was going to go ahead and move me over to the 2-5 house. I'd still be in 3-5, but I'd be over to 2-5 house.
Well, let's have you do a urine screen today and see what that shows us. Go do a urine screen.
State of Ohio versus Ty Grantham, case number TRC 231258 A and B.
Mr. Morford's case, pretrial.
believe we're going to have a change of plea, Judge. No contest with the requisite stipulation of finding facts of guilty.
Is that correct, Mr. Grantham?
Yes, sir.
Any statement you wish to make to the court before your sentence?
No, sir.
Anything in particular the state wants to point out or recommend with regard to sentence?
Your Honor, if it please the court, the breath test was 146, which is under the enhanced level. Otherwise, the only other offense is charged as Mark Lane's. We don't have any opposition if the court ordered a suspended jail sentence in the 3-day driving school. We wouldn't take any position on the amount of the fine, but we would want a 6-month driver's license suspension dating back to September the 1st.
All right, I'll impose a $600 fine.
I'm sorry, could you please?
No contest with a stipulated finding guilty. It's a first offense. $600 fine, court costs, 6-month license suspension, which started the date of the offense, 20 days in jail suspended, to 5 days community service, 2 years of level 4 probation, go to a driver intervention program. You live in Nitro?
Yes, sir.
There isn't one here in Lawrence County, but you can go to any program that's approved by the state of Ohio. And it's my understanding all the programs that are approved are in Ohio. I don't know if there's any in West Virginia, but you don't have to come back here. You can go someplace else to go to a program, but you got to do that. The closest one that I know of that's near here is in Portsmouth.
Okay.
But there may be others closer to you in Nitro than Portsmouth. But that, you have to do that, or the legislature says we're going to put you in jail for at least 3 days if you don't attend the 3-day. It's an outpatient, or an inpatient 3-day program. All right, his review hearing is going to be May 31st. Is he asking for driving privileges?
Yes, Your Honor.
Can have driving privileges for work, community service, and to go to the 3-day school. As I said, his review hearing is May 31st. If you get everything done by then, you don't have to come to that hearing. It's a check to see if you finished. Just check with your probation officer to make sure you are completed. If you have stuff left to do, you got to show up. If you don't show up, you get a warrant.
Yes, Your Honor.
He has a lane violation. I'll impose a $10 fine on that. See Mr. Major in the probation office. He's your probation officer. To the left as you leave the courtroom.
Yes, Your Honor.
Thank you, Your Honor.
You're welcome.
Thank you.
You're welcome.
State of Ohio versus Barbara R. Lawson, number CRB 22709.
Okay, now are you at, where are you getting treatment now? Aren't you in treatment?
I'm in OVP, sir.
Okay, that's what the order said.
They didn't send me with the document or nothing, though.
Is Ms. DeMint still here?
She was. Yeah, she's right there.
I'm sorry, Your Honor.
That's fine. I'm just looking for a report on Ms. Lawson.
Yeah, they were supposed to send her with one, but I think Transport picked her up before they got the report to her. But she is compliant, Your Honor. She's due to complete our program on December 23rd, and they are still working on her aftercare. I'm pretty sure she plans on doing TCC in Portsmouth.
Okay.
No,
that sounds like
In Ironton, I apologize.
Outpatient.
Let's set your next hearing then for December 26th.
Okay. Thank you, Your Honor.
December 26th, 10 o'clock.
Thank you, Your Honor.
Thank you.
You look good. You look better than before.
Oh, I know. Thank you.
Improvement.
I appreciate you giving me the opportunity.
State of Ohio versus Christopher Haberlin, case number CRB 23716, CRB 23691, TRC 191630 A, B, and C, TRD 23418. Christopher Haberlin.
Okay, there's a new charge, 23716, violation of protection order.
Stuff I've done in the past.
Do you have the new charge, Mr. Morford?
Violation of protection order, Your Honor.
Yes, sir.
Yes, I have it.
Yeah, because he has a pre-trial separate.
Oh, yeah.
Do you waive a reading? It's a violation of protection order.
Yes, Your Honor.
Enter a not guilty plea.
Not guilty, please.
State's position on bond. I think there is a bond up on, I believe, on 23691. There should be. Yes, there is. There's a $2,500 bond up on 23691. It was entered November 17th.
Might require an additional bond, Your Honor.
Mr. Morford?
Will you stay with him? Will you stay with him?
Absolutely.
He sure thinks he will stay away from him.
Well, I don't think that's been the problem. It's been text, according to the affidavit, it's text.
Texting to his sister.
I understand that's not a very strong position, Judge. Do what?
I was never told that I couldn't speak with anybody else, just her.
You can't send somebody else to do it. You can't ask him to do it. You can't ask me.
I did. I can show
We'll
you.
talk outside.
Okay, I'm going to let you go talk and then come back and talk me out of why he shouldn't have to post another bond. Okay, I'll recall this later in document.
Thank you, Judge.
State of Ohio versus Jason L. Turner, case number CRA 23638.
If Mr. Turner called the clerk in my office, he's got a fever, a sore throat, and aches and pains. In case he might have COVID, he's going to go have a test done. I would ask to come back in 1 week, given he has called the clerk, called my office. Oh, well, he doesn't have a good report, so maybe I spoke too soon. But I know he did call in with some medical issues.
Been recommended for inpatient. Color me skeptical, but I think maybe that's why he's not here today.
Well, I didn't have that report before I made that representation, but that's why he did call. I could not tell you the truth of that statement, but he said he has aches and pains and might have COVID.
Well, he also says that's why he has to use fentanyl-related compound.
I just read that.
And gabapentin and he's being prescribed buprenorphine. We know that's a no-no.
Yeah.
At least that's what Dr. Davies tells me.
I've always heard that
Should not be
also.
taking gabapentin with Suboxone. I'll issue a warrant for failure to work. You want a warrant from here, or you want to send it on to the grand jury?
A warrant from here, Your Honor.
Bench warrant for failure to appear, and, yeah, it's an OR bond.
I'll try to get a hold of him, Judge, thank you.
Yeah.
Thank you, Your Honor.
Thank you.
State of Ohio versus Michael T. Adams, case number CRA 131155.
Yours is better than the last one. It is definitely better. The last was not good. Successful. Possibly with compromise. I don't think we've had any contact with their legislature. This is a 10-year-old case. See, that's the thing, my employment is on hold until the police is taken care of.
Throwing his driver's license back.
You got a new one?
I got a new one, you can keep it.
Well, in the old days, they used to take the driver's license stapled to the ticket. They did.
So, Your Honor, this is a 10-year-old case, almost exactly 10 years old, and because of the fact that it took us a little bit of time to find the file, because it was filed away a long time ago, our efforts to reach out to the alleged victim have been limited so far. We've called on the phone and left a message, but we don't even know anymore if that's her phone. So I think what we would do at this time is nollie this case with the right to refile it and continue to try to contact her, and we may refile it again, but we may not. But we would like to have a current address for Mr. Adams.
Let's see, 1546, what, County Road?
County Road 31.
31, Chesapeake.
We have no objection, Judge, because he's actually on a warrant for RRS. This was holding up him being able to be employed there, and he understands if she would some reason show up and have a reason why she didn't contact the prosecutor, they could refile it. I mean, it's doubtful she's going to, but you understand.
All right, it'll be nollie.
Oh, thank you, Judge.
Thank you, Your Honor. Take care, yeah.
All right, thank you. Thank you. Yeah.
State of Ohio recalls Bruce Maynard, case number CRB 23710. TRC 231013A. Bruce Maynard.
This is your morphine.
Yeah, that's the one you don't have a file.
Mr. Moore, we're talking later on.
Have you seen the screen results?
I have not, Judge.
Any input from the defendant?
No, Judge. I'm at a loss, to be honest with you.
I'm going to set his bond at $10,000, cash or surety. Remand him into custody. Reschedule his hearing for Monday, December the 4th. For preliminary hearing. Mr. Morford, you are appointed. He's commanded in the hands of the sheriff at this time.
He has other cases too.
Yes, so everything will be set for December 4th.
State of Ohio versus Brittany Caldwell, case number CRB 13-1057, CRB 13-1153, A and B.
Mr. Morford's case, Brittany Caldwell. Sentencing, she's been at Bethesda.
May I approach, Your Honor?
Yes. It's a good report. Good job. So we'll just keep working on it. I mean, you've made tremendous progress since you started.
Judge, she has asked me to request the bracelet be removed, ankle monitor.
I don't get the vibe that it should be.
I mean, she hangs herself. That's all I have to say.
No, it ain't happened.
Which that happened before.
It's happened plenty of times to me.
Well, I mean with her, didn't it happen with?
No, she didn't run off. She did go on an excursion with the boyfriend. Community
Yeah, I
service.
thought, was that with or without ankle monitor?
That was without.
Okay, and that's, after that's when she got the ankle monitor.
Yeah, she got the ankle monitor after that and then did something else and then she did something else. She is doing better, but I never can
Let's
judge.
go another month.
I'll withdraw that, Judge.
January 5th. Then I'll entertain it. Give me another month. Action have consequences.
Thank you, Your Honor.
Thank you.
You're welcome.
What date, Judge?
January 5th.
5th.
State of Ohio versus Kenneth Roberts, case number CRB 23-142.
Mr. Stratton's case. Sentencing.
Things are going well?
It's a good report.
Thank you.
How do you feel about that?
I feel great. I feel great. Thank you.
Next year?
Yeah. January 8th?
Yes.
January 8th will be your next hearing. It'll be set as a sentencing, 10 o'clock. Keep it up, Mr. Roberts, you're on the right track.
Transport this one.
Okay.
That's probably an active
Yeah.
State of Ohio versus Brian Montroso, case number CRB 1733, CRB 15543 ASB, CRB 14593, TRC 111387.
Mr. Morgan's case. And it is a sentencing that Mr. Montrose has bond up, you're making payments on your fines, all right? Do you have a payment?
Yes, sir. $10.
10. I got excited there when you said 50.
Set it up.
All right, see the clerk. Next hearing will be January 5th.
Thank you. All right, just stand. Thank you. Yes.
State of Ohio versus Emily McCoy in holding here at the courthouse, case number TRD 193655.
May I put your name?
Yes.
Yeah, she's had a rough start. She's had a rough start.
Oh, okay, because I didn't know she was, luckily
You
I'm
seen the report?
I just gave the judge, I thought she was on for next week, I just happened to hear her name called.
Well, she was brought in early because
Usually that's not good.
my phone has been getting blown up about Emily McCoy.
Yeah.
Are you the boyfriend? Sir? Me. You, okay. Let's get her in the courtroom. You need some time to talk with her, Mr. Smith? Put her in the attorney room, we'll bring her out after you talk with her.
Thank you, Judge. State of Ohio recalls Christopher Haberlin. Case number CRB 23716, CRB 23691, TRC 191630, TRD 23418.
All right, this is Mr. Morford's case, and the issue is whether there should be additional bond. Talk me out of it.
Yeah, working 5, 6 days a week.
He's working 5 to 6 days a week. Are you providing for him?
Well, yeah, I got a little boy.
And he's providing for a son.
And is that with this lady, this,
No, sir.
do we have contact, you have contact information with this lady that's got the protection order? Ashley Rainey?
We do, Your Honor.
I'd like to get her input if there's been any additional contact since the 28th, which was just yesterday. After the, I guess the police came out and did a report. Has there been any additional contact? What are you gonna say?
Absolutely not.
Okay, can you try to get a hold of her? Do you have,
Yes, as soon as one of my assistants comes in here.
okay. We need Jasmine or Missy in the courtroom. All right, we'll recall after we get some.
Thank you.
Thank you, Your Honor.
input. We're ready to do Emily McCoy.
Yes.
Emily McCoy is 193655.
Your Honor, I did have a conversation with Ms. McCoy in the vehicle this morning on the way here, and last night, it was we've had a rough start, to say the least. But she did calm down last night, and this morning she seemed to have a different attitude. She got up on time, but like I told her in the car, I'm not playing with her. Like, the behavior was off the chain before that. But we would like to keep her.
As of November 13th, well, the whole reason happened, she tested positive for amphetamine, cocaine, methamphetamine, and marijuana.
She has had a rough start, Judge, just briefly speaking with her. She understands that's not acceptable. They don't have to keep her. You've got to do what's necessary.
Sorry, genuinely.
You need to do what they say or jail options.
I absolutely plan to adhere to all rules and to be respectful.
And get up when you're told to get up, do what you're supposed to do when you're supposed to do it. Because the problem, I want to give you every chance, because I'm afraid for you, actually. I think you're at great risk if I leave you back out in the community that you're going to wind up dead. Just be honest. And I don't want to see that happen. But I don't want to put you in a position where you're interfering with the recovery of a bunch of other people that are trying to get clean, and you're keeping them from getting clean because of your shenanigans. So I might be willing just to sacrifice you to help save them, and to make an example out of you. I can just make an example out of you and say, okay, look what I did to Emily. I put her in jail. You want to be Emily? You want to be the Emily that was there yesterday?
No, never again.
Okay, well then show me. You're going to get a chance. Let you go back for treatment, and I want good reports from now on. Okay, and to make sure that's happening, yeah, the 4th, we'll just keep that, well, that's too.
It's Monday.
I'm here Friday, Monday, Friday, next 3 Fridays, and I'm here Monday.
Let's make it Friday, so we'll go a week, so I'm changing her hearing to December 8th. So come back in a week, make it a good report.
Thank you, Your Honor.
You're welcome. Okay. Let's go ahead.
State of Ohio versus Clarence Mayhem, case number CRB 20-188, CRD 21-187.
Okay, this is Mr. Smith's case. It's set for trial today.
Yes, Judge, we're ready to proceed.
Your Honor,
the 2988.
one of our witnesses, Deputy Pizzelli, is on another call at the moment. He's working, but has been, so he's on the other end of the county at the moment. So we've asked, I don't know what else is left on the docket, but
This is pretty much it, other than that Haberlin case that you were going to try to get a hold of the complaint.
well, we can tell you something on that.
Okay. All right, let's call up Christopher Haberlin.
State of Ohio versus Christopher Haberlin, case number CRB 23-716, CRB 23-691, PRC 19-1638 DNC, CRD 23-418.
Where is Christopher Haberlin?
Christopher Haberlin. Christopher Haberlin.
We're not bothering you, sir, are you, by making you come in the courtroom?
What is it?
I'm sorry I'm inconveniencing you.
No, you're not, my bad.
Mr. Hill.
Well, Your Honor, Jasmine has spoken with the young lady, the alleged victim, on this multiple times since this happened. There haven't been any more issues since day before yesterday, but she is extremely upset about the fact that there were multiple violations of this leading up to that time. So that's where we stand today.
All right, so here's what I'm gonna do, since it hasn't continued since the last charge was filed. I'm gonna let your bond stand, but let me make it crystal clear. You don't even breathe her name. You don't text her. You don't post anything about her on social media. You don't go around her. You don't drive past her house, go to her work, anything. Is that clear?
That's very clear.
Or you're gonna go back to jail?
That's very clear.
Okay, so we need the pre-trials on all this. December 11th?
I'm here then.
All right, everything for Mr. Heberlin is set for December 11th. There is to be no contact or even a mention of the complaining party's name by Mr. Heberlin between now and then.
And don't have anybody else do it.
No, I didn't have.
Stay away. Forget she exists. She's dead to you.
Hey, absolutely.
Thank you, Your Honor.
Thank
You
you,
are.
sir.
Okay, back to Clarence Mahan. Is there other witnesses that you can call?
Yes.
Right here?
Yes.
And Mr. Smith, you're ready to proceed.
I'm ready, Judge. I'll just have my client potentially and another witness. So
All right,
everybody's
Clarence.
here.
Anyone invoking the rule?
Separation witnesses, I would, Judge.
Okay, I'll turn off the speaker, which I've been told doesn't do that much. I don't know if you can adjust that. I don't know if they've got it turned down out there. They were saying you couldn't hear. And anyone that's going to give testimony other than the defendant, and the state can have a representative sit within, has to stay out of the courtroom until you're called as a witness, so we hear what you know, not what you heard other people testify to. Mr. Hill, do you want to make a statement?
We waive an opening, Your Honor.
Mr. Smith?
Waive as well, Judge. We don't have an opening to make.
Call Goldie Stapleton.
Goldie Stapleton.
Goldie Stapleton?
If you come up to the witness stand, ma'am, I'll swear you in. Would you raise your right hand, please? Do you swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Matter of housekeeping, I filed reciprocal discovery today, and it did not make its way to the court file. I have the original, if I may approach. Mr.
Yes.
Bill has a copy.
And this is from an incident in January 2019?
5 years listed. Yes, sir.
Mr. Hill?
Thank you, Your Honor. Goldie,
Yes.
state your name for the court,
Goldie
please.
Stapleton.
Do you still live at 1181 Township Road, 214 North
Yes.
in Willowwood?
Yes.
And that's in Windsor Township here in Lawrence County?
Yes.
Back, it's been a while, back on January the 17th, 2019, you made a complaint to law enforcement that you had been assaulted by Clarence Mahan.
Yes, sir.
Do you know Clarence Mahan, and if he's in the courtroom, can you point him out for us?
Yes, sir. She's standing across the room here with the, okay.
The record will show she pointed to the defendant.
So how do you know Clarence Mahan?
He was my daughter's boyfriend at the time,
And what's your daughter's name?
Jennifer Stapleton.
Did Clarence Mahan and Jennifer have children together?
Yes,
And who has custody of those children?
I do.
And was that the case back then on January 17, 2019?
No, not at that time.
Were they staying with you?
On and off, yes.
Now, you allege that Clarence Mahan assaulted you. Where were you when this incident happened?
In my driveway.
At your house there in Willowwood?
Yes.
And what was Clarence doing there at that time?
At that time, he was picking my daughter up. She was living with me. He was picking her and the two little girls up.
Okay. So Jennifer and the two grandchildren were living with you at that time?
Yes.
Now, in your affidavit that you signed and swore to, you said that Clarence Mahan hit you on the face and knocked you down.
Yes, sir.
Would you explain to the court exactly what happened?
He had taken my older granddaughter out to Nevaeh. She's about, I think, 4 years old. She was reaching for me. I followed him out to the car. He locked the doors. She was still crying, begging me, Grandma, Grandma. I asked him to let me talk to her, console her. He refused. I spoke to the little girl through the window for a moment. Then I walked around the car to ask him to please let me talk to her. And he argued with me. I don't recall the exact wording at that time. But he just struck me in the face and knocked me down. Not into a mud hole.
Is this in the front of your house in the yard?
Yes, driveway, yes.
Now, was he in the car at the time, or did he get out of the car? Or
He was standing outside on the driver's side of the car.
And why were you trying to talk to your grandchild?
She was crying for me. She was afraid. She just kept saying, Grandma, Grandma. She was crying.
Do you remember, and can you tell the court exactly like how he hit you, where he hit you?
We were standing face to face, and he struck me on the right cheek.
Okay. Like a punch or?
Yeah, like a slap, hard slap.
Okay. And was it just one time, or did you do it?
Yes, it's just the one time.
And what did you do as a, did you fall to the ground as a result of that?
Yes, sir, directly into a mud hole.
Okay. So after he hit you, you fell on the ground, what happened next?
Went to the house.
Okay.
I don't recall a lot after that.
Did you call law enforcement?
Yes, sir. My grandson called law enforcement for me.
Was it a sheriff's deputy that came?
Yes.
Did you have visible injuries?
Yes, my right cheek was red. The deputy said that it was...
Objection to what the deputy said, Judge.
You can just tell us what you know, ma'am.
I'm sorry.
You can just tell us what you know, not what the deputy said.
All right, thank you. I appreciate that. Thank you. Yes, it was red and swollen and hurt.
Did you have a picture or pictures taken of it?
Yes, sir.
I'll show you what I've had marked as State's Exhibit 1 and ask you what this is.
Phil, can I see that? Mine's black and white.
I'm going to ask you what this is.
That's a picture of me with my face really hidden.
Was that picture taken on the day that
It was
you're
taken,
talking about?
yes, it was right after they left and the to your body.
Did the deputy take this picture?
Yes, sir.
And just so we can tell for sure, was there, can you see on here visible damage to your face anymore?
Yes, I can. It's up through here, you see fingerprints, I think, that's my right on my finger.
On your right cheek?
Yes, sir.
Right. I'm going to ask that Exhibit 1.
Subject to cross-examination, Judge, no objection.
Okay.
Did you see the medical treatment?
Yes, the following morning, I had my grandchildren there. I had no way to leave them and no one to watch them. So when I got up the next morning, my head was hurting extremely bad. So I went ahead and went to the emergency room where I had a CAT scan, and the doctor stated I had a concussion.
And I'm going to show you what I've had marked as Exhibit 2. Guess I'll show it to Mr.
I've seen this.
Ask you to tell me what this is, all of it, several pages.
This is the summary from the emergency room in Ironton, Ohio, St. Mary's emergency room, and it's discussing head injuries. And it goes forward to state where the doctor said that it was indeed a concussion.
When I ask Exhibit 2, do you ready, John?
Mr. Smith?
Well, Judge, unless they've got a certification from the hospital, that's a business record kept in normal course of business, I don't think it comes in.
Okay, I'll reserve on your objection. Do you got any authority or anything you want
Well,
to give me?
usually, Judge, they'll get something from the keeper of records saying this is a certified copy of the records. Just a photocopy, I don't think meets the criteria to allow it into evidence.
I mean, you got any authority?
Oh, no, not fan.
And what we've done there, Your Honor, is I've had her testify about the fact that she went to the hospital the next morning, what her symptoms were, and the records verify at least that much.
I'll take it, subject to that, I'll have to do some research.
Yeah, I understand.
But subject to that objection, it's taken.
Ms. Stapleton, were there any other people that would have been able to witness what happened besides you and Mr. Mahan?
No, sir, there was no one else outside besides myself and the little girl.
Now, the two children were in the house?
The oldest one, Nevaeh, was outside in the car. The baby, Jamie, was inside the house with her mother. My other two grandsons were in the house as well, and one's autistic and the other one was also in the house.
That's all I have of this witness, Your Honor.
You may cross-examine.
Thank you, Judge. So your testimony is your daughter was present, but she was inside the house?
Yes, she was inside the house getting the baby ready to leave.
Okay, was she outside when you were allegedly struck?
No, sir.
When you went inside the house, did you tell her, hey, oh my goodness, show me what happened? Did you have a conversation with her?
No, I did not.
Okay, so my client allegedly struck you enough to knock you down, but you didn't think it important to say something to your daughter when you went in the house?
The doctor stated that that was a symptom of my concussion, that I just had a few moments of blackout.
Do you know if my client is right-handed or left-handed? Do you have any idea?
No, sir, I don't.
Okay, you were struck in the right side of your face?
Yes, sir.
Do you know if he had any injuries to his shoulder prior to showing up at your house that day?
No, I do not know.
Judge, I have no further questions for this witness.
And you redirect.
No, Your Honor.
You may step down, ma'am.
Thank you.
And we just got word that our next witness is at Solid Road heading this way. So if the court can indulge us for a few minutes.
You got anybody else? You got anybody other, that's going to be your only other witness?
Yes, Your Honor.
I have no objection, Judge. I understand the position he's in.
All
Unfortunately,
right, court will take a recess.